You might be surprised how often I hear people say, I have this fabulous new idea. Should I get a trademark for it or a patent? And as an intellectual property attorney, my answer is always, it depends. Because here's the truth. Trademarks and patents protect completely different things. And if you mix them up and you're not really sure what your end goal is, you can end up spending thousands of dollars on a filing and still end up being exposed. Hey friends, welcome back to my YouTube channel. I'm Faith Mitton, an attorney on a mission to simplify trademark law for brand owners so that they can get a better understanding of how to protect themselves and stay on the right side of the law. On this channel, you will find tons of easy to understand, free and practical insight about trademarks so that you can make informed decisions about what to do to protect your business. And today, I want to take time to clear up one of the biggest sources of confusion among business owners, which is the difference between trademarks and patents. Understanding what these types of intellectual property are and what they protect makes an incredible difference in your intellectual property protection strategy. So let's start with the fundamentals. What does each type of intellectual property protect? A trademark protects the things that identify your brand to the public. This could be your business name, your logo, your tagline, your product packaging, or even a unique sound or scent. These things are called brand identifiers or source identifiers, and they help consumers to recognize where a particular product or service comes from. But there are different layers of trademark protection depending on where and how you use your trademark. For example, the moment you begin using your trademark publicly, you immediately begin to accumulate something known as common law trademark rights. Yes, these rights come into existence automatically without making any filings or paying any legal fees to any government agency. But they're also very limited in that you cannot get protection for your trademark in the places where you have not made sales and penetrated a market. So common law trademarks can be very limited in the kind of protection they give you. You can go the next step by registering your trademark at the state level, which will give you protection within the borders of the state in which your registration was filed. Now that might be okay for a purely local business like a restaurant or a boutique that never plans to expand outside of its state. But for anyone who is building a business that wants to expand and have customers and clients from all over the place, then a federal trademark registration is the gold standard. At the federal level, which is the kind of trademarks that I love filing, registration with the U.S. Patent and Trademark Office gives you nationwide protection and a clear record of ownership over your brand. It doesn't matter whether your trademark is a word, a design, a sound, a scent, a domain name. The purpose of filing a federal trademark is always the same: to define and identify who owns the trademark and to prevent confusion by the use of similar trademarks in the marketplace by competitors. Now let's take some time to contrast that with patents. Patents protect inventions, things that are functional, useful, or innovative in some way. To qualify for protection, the subject of a patent must be novel and non-obvious. This means basically you're doing something new that has not been done before. And unlike trademarks, which can exist at the local, state, and federal level, patents in the US only exist at the federal level. And there are different kinds of patents, each serving a different purpose. A utility patent protects how something works. That might be a new machine, a new process, or a new formula. A design patent protects how something looks, the ornamental appearance of a product. And a plant patent, which is less common, protects a newly invented or discovered plant variety. And while they have their distinctions, these three different types of patents all serve the same general purpose: to give the inventor exclusive rights to use the patent for a limited period, usually 15 to 20 years, depending on the type of patent. Interestingly enough, although trademarks and patents are distinct, they are both handled at the federal level by the same agency, the United States Patent and Trademark Office, or USPTO. But although these applications get filed and processed by the same agency, they take very, very different paths on the way to approval. With trademarks, the pre-filing process usually begins with something known as a trademark clearance search, which is the way that trademark professionals check to see whether there are any conflicts that would prevent the approval or use of the trademark that you have chosen. A trademark conflict may exist if the trademarks look similar, sound similar, and or have similar meanings on the one hand, and if they are used to promote related products and services on the other hand. If the trademark clearance search shows a clear path to approval, then filing the application consists of completing an online questionnaire, which looks simple but is deceptively simple. On the questionnaire or the application, you identify things like who will own the brand, what is the brand, what will the brand protect. But filing a trademark application is nothing like filing an LLC, for example, where you're basically going to get approved no matter what. As I mentioned, the conflict landscape matters, and not only can the USPTO raise objections to your trademark application, other brand owners may raise objections as well. So it is worth it often to take the time to work with an attorney to prepare an application that can be defended against these kinds of collateral attacks. And doing that is as much an art as it is a science. But I digress. What does the actual process look like? Once you hit submit, the USPTO assigns an examiner to your application. This person is an attorney who works for the USPTO, whose sole focus is on that specific type of intellectual property, trademarks. They will review your application for the many requirements that trademark applications must satisfy in order to be approved. If it fails to meet a requirement, the USPTO will send you an office action denying approval of the application and giving you an opportunity to fix whatever is wrong. If you fix what's wrong or you don't get an office action in the first place, the next step is publication, during which third parties can raise any concerns to prevent the approval of your application. If any third party does have a problem with your application, they can take action by filing an opposition, which is a specialized type of lawsuit held before the Trademark Trial and Appeal Board. If you overcome any oppositions or if you don't receive any and everything else checks out with your application, then very likely your trademark application will be approved. And I want to reiterate that while the USPTO government filing fees may just be a few $100s per class for your trademark application, the real investment that you should be making is in legal guidance about what and how to file. Because here in the US, we do operate on a first to file system, meaning that we reward people who are proactive in taking the steps to register their trademarks early. But just being first to file isn't the end of the story. You want to be the first to file correctly for the brand that you want to protect. Every single submission that you make to the USPTO becomes part of a public record that anyone can see and access, and which can be used against you in disputes. A poorly drafted or even premature filing can weaken your rights or limit what you can protect later. And it is very difficult, if not impossible in many cases, to change a filing that's been made with the USPTO. That's why strategy matters just as much as timing, and why getting it right from the start is so critical. Switching gears, the patent application process is much more tedious and technical than the trademark application process, although they are both equally complex in their own ways. Before submitting a patent application, most patent applicants will work with a patent attorney to do a prior art search. This kind of search is how inventors figure out whether their invention is truly new and innovative or just a play on something that already exists out there. But some inventors start with a provisional patent application, which isn't reviewed by the USPTO and does not undergo a prior art search. This type of application simply holds your place in line and gives you the ability to use the patent pending status for about 12 months while you continue refining your idea or invention and testing its market potential. But to actually earn a patent, you must file what is known as a non-provisional patent application. That's where things get pretty rigorous. The filing must include detailed drawings, written specifications, and very precise claims that legally define your invention. Then it goes through examination with the patent examiner, who may issue multiple rounds of feedback or office actions requiring clarification or change. That back and forth can take years. And once you add in attorney time, government fees, and ongoing maintenance costs, the total investment can number in the tens of thousands of dollars. So both systems are very rigorous, but for very different reasons. Trademark law is focused on avoiding confusion. Patent law is focused on rewarding innovation. And that difference carries over into how infringement works too. Trademark infringement is what happens when someone uses a confusingly similar mark on related products and services, leaving consumers to believe that two different brands are actually the same. The harm here is reputational. The brand's identity, value, and goodwill are at risk because of the confusion. Remedies usually include injunctions to prevent a competitor from using a brand that is protected, and in some cases, it may also include damages or disgorgement, which is handing over of the infringing brand's profits if they intentionally stirred up confusion and tried to mix people up. Patent infringement, on the other hand, is about use without permission. If someone makes, uses, or sells your patented invention without authorization, then that's infringement. The harm there is economic. You're losing the exclusive right that you have to profit from your innovation. And because patents are federal and time limited, remedies can include significant monetary damages as well as injunctions. So even though trademarks and patents protect intellectual property, they do so on different levels towards different ends. One is about protecting reputation, which is forever, which is why trademark rights can exist forever, whereas the other is for rewarding innovation. And because innovations are constant, the patent rights that come with innovation are time limited. And this is where having legal counsel really matters. The real skill lies in knowing which type of protection you need, when you need it, and how they can work together. A good IP attorney will look at your business as a whole, what you offer, your branding, your growth plans, etc., and help you prioritize what to protect first, or to figure out if there's something that you should be protecting simultaneously. Because sometimes both a trademark and a patent might apply to the same thing, just from different angles. A great example of this is the Coca-Cola bottle. The company holds a trademark for the trade dress of the bottle, meaning the distinctive shape that consumers immediately recognize as pointing to Coca-Cola, but they also held a design patent for that very same shape when the bottle was first introduced. The patent gave them exclusive rights over that design for a very limited time to reward innovation because no other beverage bottles at the time looked like that. But once the patent expired, the trade dress registration continues indefinitely, providing protection for their unique bottle shape as long as they continue using it in line with the requirements of trademark law. So brand owners can sometimes layer these different intellectual property protections strategically because what you have to prove to show infringement are different, the remedies are different, and the exclusivity and time limits are also different. So when used together, they can create a strong barrier against imitation, giving you protection on multiple fronts. Knowing where to start and where not to overextend is what keeps you protected without wasting time or money. So a knowledgeable IP attorney is worth their weight in gold to help you figure this all out. And if you're ready to explore trademark protection, I would be more than delighted to assist you. It is my joy to help brand owners protect and expand their brands in a smart and strategic way. You can find info in the description about how to book a consultation or learn how to become a client if you're interested. And if you enjoyed this video, please like it so the algorithm can distribute it to other people like you who may also benefit from it. Be sure to subscribe for more trademark content and to turn on notifications so you never miss when I post a new video. If you have questions or thoughts to share, please drop them in the comments. I read and respond to each one personally, and I would love to hear from you. Thanks as always for watching, and stay tuned for the next video.